Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Sun Lakes Marketing Limited Partnership et al. Versus State of Arizona and the Department of Revenue. Our case number 16-0011. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. We have read the briefs. We've been through the record below. We're familiar with the facts and evidence in this case as presented in the proceedings in the tax court. So please feel free to keep that in mind as you present your arguments here today. We've conferenced the case this morning, and so we're prepared to listen to you this morning. We are recording these proceedings, both audio and video, and in a matter of days, the video from this conference will be posted on YouTube. So if you want to see what you look like, go to the site. Importantly for our purposes, however, as you approach the podium, please identify yourself and your client for us and for those recordings. With that, Mr. Teasdale, you may proceed.
May it please the Court, I'm Scott Teasdale, Assistant Attorney General representing the State of Arizona and the Department of Revenue. The primary question in this case is whether a subdivision developer who installs sanitary sewer systems and stormwater features at a residential subdivision, which systems are transferred to other owners for ownership and operation, is entitled to the ARS 43-1170 credit for pollution control equipment for expenses incurred in installing those features. There are two key points that we think control this outcome. The statute at issue requires that eligible property must be used in the taxpayer's business to control or prevent pollution. As such, the department does not interpret this credit as allowing for a credit for people who build pollution control features to transfer to another to use because building to transfer is not itself a qualifying use.
So is it the department's position that the utility, as to the wastewater part, is it the department's position that the utility that acquires the system gets the credit, acquires and uses the system?
The utility has a far stronger claim for the credit because it clearly is using and operating the sewer system for the normal function of a sewer system. Below, the department advanced the theory that it has applied from the beginning of this credit, which is that the credit was intended for those who are generating pollution in their trade or business and then buy equipment to ameliorate that pollution. The department chose to settle the utility claims in this case and simply litigate the developer claims. Evidently realizing that was probably not as strong a case to move forward on.
Okay.
Whether a particular utility would claim the credit in any particular case might depend on other facts. But generally speaking, they're certainly operating them in their trade or business to prevent or control pollution.
What about in the stormwater property? Who gets that tax credit as far as the department's concerned?
Well, generally, no one's going to get a tax credit for stormwater property in subdivisions, and here's why. Typically, these properties are transferred either to a homeowners association, which owns common areas, and the homeowners associations are not paying income tax. They are nonprofits.
Probably not paying for the stormwater retention areas either.
No, or sometimes they're transferred to municipalities. In a lot of subdivisions, they're sort of park-like areas that some of which are transferred to cities to own and operate as parks and also serve a stormwater function. There is not, however, a principle in income tax law that because there is a credit that somebody has to get it. This court dealt with that in the Home Depot transaction privilege tax, bad debt deduction, and the earlier case, the Daimler Chrysler transaction privilege tax, bad debt deduction, and essentially held simply because one person is not eligible doesn't mean the other person's eligible. So in some cases it may be that there are expenses incurred which are not credit eligible for any claimant. And in fact, in this case, in the sewers, one of the utilities at issue is Pima County Wastewater, which as a municipality is not going to be a taxpayer. The other is a company currently called Liberty Utilities, which was Litchfield Park Service Company, which is going to be as a private entity, a taxpayer. So you could have both just within the realm of sewer property.
And certainly there's nothing in the record to indicate that any individual homeowner has claimed a credit as part of the purchase price of their lot or residence.
No, Your Honor, and because it is a business tax credit, generally a residential homeowner is not going to be using that. Additionally, you're talking here not about on-site sewers, which were what it was at issue in Microchip, but you're talking basically about a municipal sewer system under the street, which is never going to be acquired by the homeowner. Now, the history of the bill, the original statute in 1994 gave the credit for expenses that the taxpayer incurred during the taxable year to purchase real or personal property that is used to control or prevent pollution. It did not have a requirement that the taxpayer itself be using the property. In 95, the legislature saw that that was a mistake and retroactively amended the credit to require that the property that would qualify be used in the taxpayer's trade or business in this state to prevent or control pollution.
That's not the statute that we're dealing with, is it?
That is the statute that we're dealing with. That language is in Section A, remains to this day. They started out in 94 without having the requirement of taxpayer use. They added that in 95 retroactively, so effectively from the inception of this credit, the taxpayer use requirement has been in the statute.
What's your best case for the proposition that B, subpart B, which talks about including, uses the word including, establishes a does not expand A. In other words, as I understand your position, it's
illustrative of the types of property under A that can qualify for many types of industrial pollution control equipment. There is going to be regulation that will impel, say, sulfur dioxide removal, scrubbers, things.
But Microchip talked about, decided whether the property needed to comply with B in order to be eligible for the credit. And as I understand Microchip, it said no, it doesn't need to comply with B. Here it's the opposite. The issue is whether, if it complies with B but arguably doesn't comply with A, is it covered? What's your best case for the proposition?
The best case is that there are requirements in A that have to be met, and if you just meet B, that wouldn't satisfy the credit. For example, if you didn't incur expenses, well, someone else incurred the expenses, well, then you're not going to get it. That's a requirement from A that's nowhere mentioned in B. But the core issue is, of course, use in the taxpayer's trade or business to prevent or control pollution is the core. But there are other requirements which are not in dispute in this case, such as do you have a basis in the property? Have you adjusted your basis? Those aren't before the court because those aren't at issues in the case. But if you met B but didn't meet those other requirements, would you still qualify for the credit? And we think all those sections have to be read together.
Have you got a case that says that?
Just general statutory interpretation, Your Honor.
What?
The Though actually, I think that Microchip did just say that B is illustrative of property that can qualify under A.
What about the Watts case?
Well, the Watts case, I think, is our strongest case. In Watts, you had a lessor that was leasing water spray trucks that were used in many cases to spray down dust. They could also have other functions. If you wanted to have a mud pit party or something, you could use it for that. But in many cases, there was dust control, which is an arguable pollution control use, being made of by those that property by people who are renting it. However, the court said, no, this is not a lessor's credit, and it is not a retailer's credit. That's not use. You don't get to claim somebody else's use to qualify yourself for the credit because it is a requirement of taxpayer use in its trade or business to control pollution. And again, this is very important because the number of cases where you can have multiple claimants. If Waste Management builds a landfill or contracts to have a landfill built and puts in a pond liner so that pollution doesn't leak out of its landfill, and that's then transferred to Waste Management, they would presumably have a claim for pollution control equipment for at least part of this facility. But does the developer who's building it also get the claim?
Well, in this case, it's true, isn't it, that these taxpayers incurred the expenses of the purchase and installation of this equipment.
Yes, there's no doubt.
And there's no doubt that the equipment is used. In fact, it qualifies under the statute as pollution control equipment. So how is the construction and installation of that qualifying equipment not a use in the developer's business?
If you're looking at whether it's a use in the developer's business, it is a business use. If you are simply looking at deductibility of an expense, is this a trade or business expense? Yes, it is a trade or business expense. Okay, that's basically the standard for deductibility under IRC Section 61. This wasn't, done in for a non-business use. Okay, but that's not what the statute is about. The statute says that it's use in the taxpayer's trade or business to prevent or control pollution. And there are essentially two possible interpretations. One is you've incurred this business expense and the property will eventually perform a pollution control function in the ownership of someone else, or no, you have to retain it and use it. And we think that it is a user's credit, not a builder's credit, because a builder is essentially in the same position as a lessor or a retailer who is acquiring property to transfer to others who are then going to use it. Now,
so in the department's view, these developers would have to retain ownership of that particular pollution control installation or equipment in order to qualify for a credit?
Yes, it's a credit to acquire property which is then used, and that inherent in that concept is that you are owning this property during some sort of material period of use, not simply that you're putting it in and immediately transferring it. As to the sewers, we know they never operate them. They can't legally operate them. Okay, you either have to be a regulated utility at the Corporation Commission under its regs to own and operate sewer property, or you have to be a municipality.
It seems to me a purpose of the statute is to encourage entities to install this pollution equipment. How is that purpose advanced by requiring those folks who incur the expenses to do something other than simply incur the expenses?
That's really a question for the legislature. This is not a generalized business credit to stimulate the economy. You could say that about any credit. And sometimes the legislature chooses to do things like give a construction materials credit that would be broadly applicable and wouldn't have to be tied to a particular type of project.
Let me ask you, now, going back to the issue of the use, as to the stormwater, what of the fact that the subdivisions do use for a period of time the streets and the common areas until the point when they sell them?
Well, I wish we had on the record how long these stormwater features were actually retained in the ownership of the particular developers, but they have essentially asserted that it's a builder's credit and that they don't need to show any particular period of retention and use. So I don't know whether the homeowners association got these things immediately on completion. I don't know if the land on which these were installed was already owned by the homeowners association, or whether it was transferred years after the fact. It's simply not in the record. Obviously, if they had retained ownership of this for years, that would be a different case factually from what is before the court, which is essentially a claim for a builder's credit without any evidence of a particular material amount of use. Now, on the stormwater, there's nothing in the legislative history that indicates that the legislature was ever contemplating that decorative lakes and subdivisions was what they were looking at. They enacted the first bill after amendments to the Clean Air Act that were going to require new scrubbers and things to be put on power plants in this state. They had Intel considering building a plant out in Chandler, which the legislative history indicates this was one of the credits that Intel wanted on its wish list, and again, that's industrial pollution control. And let's distinguish this from microchip. In microchip, you had affidavits from engineers talking about the various pollutants, some of which are fairly routine, things that could run out of parking lots from drippings on the employees' cars and so forth. But they also said that you have chemicals being delivered on these sites, and if there's a chemical spill, the stormwater retention is going to retain this industrial pollutant so it doesn't get washed off site. So again, we're still talking about industrial pollution control in the case of microchip, because both those plants were chip plants and combined with office facilities. It's a very different type of property than simply residential subdivisions. And there's nothing in the legislative history that indicates the legislator was contemplating a subdivision credit or was attempting to stimulate that type of business. Now, I think there are two symmetrical and opposite rules in interpreting tax statutes. Statutes imposing taxes are, quote, should be construed liberally in favor of the taxpayer and strictly against the state, and inasmuch as a taxing statute must be strictly construed, we cannot extend its application to include something not specifically covered by the language thereof. That's from the Abasco case. For exemptions and deductions and credits, that standard is effectively reversed. And again, from Abasco, every interpretation shall be against exemptions from taxation statutes. Sort of a yin and yang here in the standards for interpretation, both of which come back to the idea that it should be clear on its face. Well, let's imagine if the state imposed a tax on property that was used in a taxpayer's business to prevent or control pollution, and the state was coming in and saying that this taxpayer owes the tax because they're building pollution control property that's then transferred to other people to use that property. That's effectively the inverse, but it's the same issue. Is it a user's credit or is it a builder's credit? And the department thinks that when you look at the standard of interpreting both taxing statutes and credits and exemptions, which are effectively flip sides of each other, that you have to look at the language and say, does this make sense? Okay. I don't think if there's a statute requiring you to use property to trigger a tax, that it would be interpreted to say, well, you're the pre-use person who creates property which will eventually be used for that purpose.
You would agree that we have to read the two sections of the statute together, A and B?
Yes, Your Honor. The other argument against B is many of the statutes, there are many requirements when you make a product that you have to put something in, but that does not create a use of that product. We've seen this before in other cases out of state where people were claiming, actually in the enterprise leasing case in this state, where you had integrated automobile pollution control equipment. Now, that one went down because of a retroactive amendment, so it didn't have to reach the issue. But there's out-of-state cases that say, no, an auto manufacturer installing pollution features that have to be installed by statute is not going to get a tax benefit under the similar type of statute as this. I don't recall the site, but I'm sure it's probably cited in the enterprise leasing case. And I say I only have a few minutes left. Do you have any questions?
We're good.
No?
All right. I'll reserve 2 minutes. Thank you.
Thank you, counsel. Mr. Irvin?
Thank you. May it please the Court. Patrick Irvin here for Sun Lakes et al. I do agree with Mr. Teasdale that there are issues here that should be left to the legislature. It's just the issues that they raise as justifying denying the credits here. The two sections of the statute do need to be read together. The word includes is very important. As Judge Johnson pointed out, in microchip, the issue was whether B limited A. Here, the department is arguing A limits B. Reading them both together, they are consistent. There are certain requirements of A that have to be complied with. There have to be a purchase. It has to be a trade or business, because that wasn't in B during the years at issue. It was added in 2005, but it wasn't in the years at issue. But A is a fairly broad reference to used in the trade or business to prevent or to control pollution. What B does is it includes certain things. And under general rules of statutory construction, as microchip found, that was illustrative. It also pointed out that it can be definitional. As the supplemental citation tried to make it even clearer, it can be an expansion. But in any case, it includes. The department's interpretation would exclude things that are specifically included by B. And this is
It's your position that paying for the installation or construction of this equipment or devices qualifies as a use under A.
if it's if you purchase the property, if you're installing it as part of your trade or business, and it's required by government regulation, yes. Constructed or installed. B talks about direct use, constructed or installed. It's or. Any one of those could do it.
Well, Mr. Teasdale suggests that what it really means, use really means operate after incurring those expenses. What do you say about that?
If B said direct use, construct, and install, I would agree. But it says or. Install is different. What it does is define what used in the trade or business to prevent or control pollution is. Now, in this case, we have developers who put together subdivisions. This is not a short-term thing. It's not just building a house and selling it. They're not doing it for somebody else. They're doing it as part of their inherent trade or business. They build these things sometimes with the hope of selling, but some of the things they retain ownership in. And I'll get back to that. There is no evidence at all in the record to show that any of the stormwater property was ever transferred to anyone else, or that there was ever an intent to. But in terms of part of the trade or business of putting the subdivisions together is having to comply with all these government rules that require you to do these things. This is not a government regulation of the contractor. It's not a government regulation of the home buyer. It's a government regulation of the developers who have to meet all of the requirements. They have to get all the permits from the environmental agencies, from the local agencies, to put this property together, from the real estate department to subdivide. There's a whole plethora of requirements that they have to meet as part of their business. So by putting these things in, that is a use of their trade or business. But if there was any lack of clarity about that, B defines it.
Well, what about the cases that Mr. Teasdale referred to that hold that if a manufacturer is required by law to include a safety device on the car that the manufacturer is selling, and there happens to be a tax benefit for the cost of safety device, he can't take that. Mm-hmm. Would that line of authority apply here?
No, for a couple of reasons. One is it's a very different business. This is, and we have a very wide variety of businesses around that the statute has to apply to. So the business of being a subdivision developer is not making a product that you're then just selling to somebody else. It's a much more ongoing. But even more importantly, in 2005, the legislature amended the statute to deal with exactly that situation. It says that from 2005 forward, you can't get a credit for property that becomes a standard and integral part of another piece of property. So the legislature has addressed that, but they've done it in a prospective only. A lot of statutes, you're never quite sure what the legislature means. But this statute, it's a little easier to see what they meant, because on 2 different occasions they said, gosh, we didn't mean that. And they amended the statute and made it retroactive to 1994. In 2005, they took a very different approach, which was, we're going to amend it, but we're not going to make it retroactive. It's going to be prospective. And in 2005, most of the claims in this case, as well as I think microchip and any other cases, had already been filed. To the extent the legislature the legislature was probably aware of the issues that are here. And again, they didn't make it retroactive. So to answer the question of an integral part, that was a change of law. So at least during these years at issue, that's just not an issue. And I don't think it's an issue for these developers at all.
What about the, getting back to the A and B and whether the expense needs to qualify under both. The supplemental authority that you filed, I forget the name of it, but I looked at it, and I didn't see that as addressing a 2-part statute like we have here. I think, as I'm remembering, the supplemental authority read including to mean, it doesn't necessarily have to include, it includes a lot of things. But what's your best authority for how to interpret a 2-part statute as we have here, the second of which says including?
I think the Bernhardt, which is the supplemental authority, was a 2-part statute, because in fact it refers to indeed in subsection B. It's a different statute, but it talks about the included part expands the definition and adds subcategories that ordinary usage would not otherwise place there. So to the extent the department argues that in A, it talks about use in the trade or business to prevent or control pollution. As I say, I think the taxpayers here did use it because it's part of their business to do it. But even more, B expands it. It certainly defines it. It specifically says it includes construct or install. If you're doing it to comply with government regulations, which the department has not objected to, and there is some references in the reply brief perhaps to that, but neither below in the tax court nor in their opening brief do they ever argue that these expenses were not incurred to meet or exceed government regulations. So in terms of, we go back to the statute. The statute says you incur expenses to purchase property. If it's trade or business property, it includes items that are installed or constructed to meet these government regulations. And that applies to all these properties. We do need to differentiate, of course, from a factual point of view between the sewers and the stormwater. As I said, there is absolutely no fact in the record showing that there was ever an intent to transfer the stormwater or that it ever was transferred. So to the extent Mr. Teasdale mentions that if they held it for a period of time, that's a concession that the stormwater qualifies. It wasn't, we didn't put in the record how long they held it because below it was never an issue how long they held it. The argument was that you aren't the end user, but there was never an argument you have to prove how long, which actually comes back to the statute. How long do we have to prove? Do we have to prove a year, 2 years, 3 years? If we presented all this evidence, where would the line be as to what qualified? And the statute doesn't say.
Talk to us about that aspect with respect to the sewer. Could someone in the develop office have flushed a toilet before the utility bought the system?
Probably the utility would complain. The sewers had to be in before human occupancy.
Okay.
I think before they started to process sewage, you had to have a utility online. There's a time gap there. And there's no question that, and we've conceded it got transferred to the utilities. But they were installed and constructed pursuant to government regulations that applied to these taxpayers. It didn't apply to utility. They had their own issues. But in terms of the reason the sewers were installed and constructed, it was to comply with government regulations as that applied to them. They had to get the permits. They had to submit the plans. They had to comply. That was part of their trade or business with doing that. The statute doesn't say, again, it doesn't say direct use, install, and construct. Install or construct are separate items. And if there's a possibility of multiple claims, which we've made very clear we don't think there are any here, then that's again a question for the legislature. The legislature has dealt with that issue in other circumstances. We mentioned in our brief at page 34 that back in 2000 the legislature dealt with neighborhood electric vehicles, which if you remember those, you got a tax credit for it. There was no limitation on whether it was used or new. There were people who were buying them and then selling them to their neighbors and claiming multiple credits. And in 2000 the legislature, the golf carts, yeah. I think it was in the paper that Chief Justice Lackett bought one, and he was unhappy about the change. But in any event, the legislature dealt with it. They put a limit and said, you only get it. You can't get it for used anymore. The legislature has shown with pollution control that they start big and then contract. Sometimes they contract retroactively because they say we never meant that. Sometimes they contract prospectively because they say, we find that it doesn't quite work. So we're going to make a change, but it's prospective only. And that's what we're dealing with here. We're dealing with a legislative change in 2005 that eliminates most of the issues raised here, as it did eliminated most of the issues in microchip. But it was prospective only. So for the years at issue, the legislature didn't want to make a change that applied here, and certainly even after microchip, the legislature didn't make a change.
So both parties have cited to us both statutes, 431170 and 1081. They're identical, I believe. Which one do you want us to focus on? Which one is applicable in your view?
I think both of them are applicable because we have different entities. We have corporations and we have LLCs and partnerships.
Okay.
So that's why.
That answers the question.
That's why in my brief I tried to consolidate them. They're the statutes. As far as I could see, they were amended identically in each case. But in terms of how it applies, that works. There was a question about Watts. I think Watts is a totally different situation. There was no proof that the taxpayer itself used it. But one important thing, which I think by itself overcomes Watts, is that the court separately analyzed B. The court looked at, is there any government requirement that they use these or that they install certain equipment on it? And the court said no. So Watts would have been very different if the taxpayer in that case had been subject to specific governmental regulation that required them to do certain things. But even the court in Watts looked at B as informing A. So it looked at A and B, and B would have tipped the balance. But
how do you get away from the fact that the court in Watts had two reasons, as I read it, for proving the disallowance? One, there was no certainty that the property would be used for pollution control, but also the court said, and that taxpayer wasn't using it.
Well, and I think that's it. The taxpayer, the using part focuses just on A, by standing alone. But if the taxpayer had been subject to government regulations that required them to put pollution control devices on it, and putting aside the fact that it was a motor vehicle, then B would have informed that as to what use means. In that case, the taxpayer didn't use it at all for pollution control. When they held it and it was not being leased out and it's sitting in their lot, it's serving no pollution control function whatsoever. And they had no business that ever used it for pollution control. And whereas here, the taxpayers, certainly for the stormwater, but even for the sewers, have a reason of putting them in because as a business reason they have to put in this pollution control or prevention property to comply with both government regulations, but it's just part of their trade or business in order to operate as a subdivision. So, Watts is just very distinguishable, as the tax court said. There was no proof that the taxpayer used it or was subject to government regulations. Here, there's really no question that the taxpayers are subject to government regulations, and B then informs what use in the trade or business to control or prevent pollution means. And again, I want to emphasize one fact that Mr. Teasdale mentioned, that these systems were transferred. Certainly the stormwater was not. That is undisputed in the record. That there's nothing in the record, or I should rephrase that. There's nothing in the record showing a transfer or an intent to transfer. And in any event, the intent to transfer is not in the statute. There is nothing in the statute that says you get the credit except if you have a subjective intent to transfer. It's just not there. In many ways, that's a sort of a repackaging of the primary purpose argument that was rejected in microwave. You don't look at what the purpose of the buyer is. You look at whether the terms of the statute are met, and in this case, they are. There's the purchase of the property for a trade or business, and certainly it was all done to meet or exceed government regulations. It was installed or constructed. There's no holding period. There's no but if you intend to transfer, or even if you do transfer. Those are questions that could be addressed to the legislature. In fact, in 2005, the legislature addressed these, but on a prospective basis only. The court has no further questions. Thank you.
Thank you, counsel.
I wanted to speak briefly on the 2005 amendment and why I don't think the court should go there in interpreting the prior statutes. The court in Microchip decided in dicta that the 2005 amendment was a change in law. Well, under Article 9, Section 22, it would need what we call a Prop 108 endorsement, which the bill did not, in fact, have, if it narrowed the law such that revenues to the state would increase. So, if it actually is a change in law, then there's a question about whether it is in fact valid. And one day we may have to defend this in court, so we're going to reserve that defense for that time. But I don't think that since there was not a Prop 108, the court should assume that it was a change in law. There were 7 House bill summaries, all of which said that bill was a clarification. And they said it was a clarification because the Department of Revenue represented to them that this is the way we're interpreting the prior law, and the legislature then made it express in the 2005 amendment. But treating the 2005 amendment as defining the terms of a statute whose language came from 95, we think is going off the rails.
Did you make that argument in your petition for review in Microchip?
I don't recall whether I made that particular argument in the petition for review, Your Honor. One other thing on the idea of time of use, which I think is important. The department tried this idea, well, there's no requirement for a particular time of use in Duval-Serraria involving spare parts. Right? The use tax is on storage, use, or consumption of tangible personal property, and Duval was storing tangible personal property and therefore had touched the base, the taxable act was there, and the department imposed the tax on spare parts. And the court said, wait a minute, these spare parts, once they're installed, are going to be exempt manufacturing equipment. You can't just look at the snapshot. You've got to look at the big picture. And when you're looking at a claim of use, time of possession, how long you're using it, that you are using it, is actually a very crucial factor. We think you have to look at all the facts and circumstances surrounding claims of use and not simply say, well, there's no time limit, so you can just touch the base and therefore satisfy the requirement. Thank you, Your Honor.
Thank you, counsel. We appreciate the arguments here this morning, as well as the written briefs that were filed in this matter. We'll take this under advisement and issue a decision in due course. And with that, we're adjourned. Thank you.